We're joined by former federal prosecutor Mitchell Epner. Mr. Epner, thank you for joining us again.
Mr. Carr, thank you for having me.
My first question here is, who are the plaintiffs and why are they the right ones to sue?
Well, you've hit on the right question. The plaintiffs are a bunch of states who are all going through the Missouri student loan program as their basis for claiming they're the right ones to sue, and two individuals. And one of the biggest questions in this case is whether or not any of the current plaintiffs have the right to sue. It's called standing, and it means that you, as the plaintiff, have to show that you were directly and materially affected by this law. Just because you don't like it, you can't go and sue. You have to show that some damage is either being done or threatened to be done to you. And the federal government has a very strong argument that none of these plaintiffs have standing.
And so you mentioned that word directly, and the idea that they are directly harmed here is kind of an issue, because I think even the Missouri borrowing situation, they were sort of saying, well, this entity may not get its money, it may not be able to pay the state back. It's a lot of downstream effects, but every federal policy is going to have downstream effects. Could every state just challenge every policy?
Well, that's one of the fears that people who are looking at this case have, that if the states are held to have standing, whether or not they win, they could, every time the federal government makes a change that reduces state tax collections or reduces money that states get from fees, that could give the states the ability to sue to try to stop the federal government from doing what they want to do. And that's something that if you're Missouri and you're a red state and you want to stop Biden, you also have to think that the next time there's a Republican in the White House, there's almost certainly going to be a Democratic attorney general in a state like New York or California who would try to stop those programs.
And according to the New York Times, during the Trump administration, states filed 155 lawsuits seeking to block federal policies from the Trump administration. Also, according to the New York Times, it's about 56 of those lawsuits from Republican-led states seeking to stop some of Biden's policies. But in this case specifically, to get back to the folks that are impacted, whether or not millions or billions of dollars in federal student loans are going to be forgiven, if the federal government is the creditor, why can't the federal government decide not to collect?
So the real question is whether or not the underlying law gives the discretion to the president to decide to waive payments. And the federal government has a pretty strong argument here, because the law literally gives the discretion to waive or modify anything, including payments.
And so the case that they're using here, the 2003 HEROES Act, it gives the Secretary of Education, who's the relevant cabinet secretary in this case, at the president's behest, the right to make changes during a state of emergency. The state of emergency here is the pandemic. This was a pandemic era piece or executive order. And so what's your opinion here of the legal footing then that they are on, using a 20-year-old law during a state of emergency that even the Biden administration has said we will soon be out of, and that is the pandemic and the state of emergency there?
So I believe that in a world where the Supreme Court is just calling balls and strikes, as Chief Justice Roberts famously said during his confirmation hearings, that's all he would do, this law would be affirmed. Given the 6-3 Republican majority, I am concerned that this law, it's not law, that this executive action may not be affirmed, and it may not be affirmed in a way that would put all executive action in the future in real jeopardy.
So is there any better legal strategy then, given the standing issues and who can and can't sue, for student loan cancellation, to fight it or to support it?
So the problem that the federal government will have is that and this is one of those things where a good thing has a slight defect. We're soon going to be out of the emergency, the COVID emergency. That's a very good thing. But the COVID emergency was the hook on which the Biden administration hung this entire plan, I don't see another very good hook out there once we're out of the emergency.
Yeah, let's hope we don't have another nationwide state of emergency. I would prefer that. There's also, based on the pandemic and the state of emergency, some immigration issues. So are there some unintended consequences of this ruling that could come as early as, June 1st?
If the Supreme Court rules against this executive action, I think that this case will become famous 30, 40 years down the line because it will fundamentally change the balance of power between states and the federal government.
Thanks for watching. Go to newsnationnow.com to find NewsNation in your cable lineup. And don't forget to click the red subscribe button below to get more of NewsNation's fact-based, unbiased coverage.